Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukkara. This video is regarding the confession made by an accused to the police and which was videographed. Will it be admissible in evidence or not? 100% no. That is what is stated by the Honorable Supreme Court of India. So no doubt, please remember, according to Section 27 of the Indian Evidence Act, the recovery or discovery of a new fact is admissible, but not all the things which are narrated in the so-called videograph. We are all under the impression that yes, the technology has improved like anything. The Information Technology Act 2000 has come. So why don't you make the evidence recorded through videographing admissible? Yes, it is admissible under Section 65B of the Indian Evidence Act, provided you prove that this is generated through a particular instrument. For that reason. But please remember, basic law is Indian Evidence Act. So Indian Evidence Act says if the confession is made in the presence of police, it is not admissible under Section 25. Even though the confession is made in the presence of mediators, if the police are present, no, it's not relevant. Similarly, Section 27 gives a leverage stating that only that part which is made as a recovery, that much is only relevant, not other parts. This you know. But out of anxiety, the Karnataka police, they made a confession and they have videographed, the accused made a confession, it was videographed and shown to the court, and up to High Court level they believed and they convicted the accused also. But Supreme Court did not agree. Now you can see the case. So CJI also there. CJI, Honorable Justice U. Lalit, S. Ravindra Bhatt and Sudhanshu Dhulia in the case of Muni Krishna alias Krishna. Muni Krishna alias Krishna versus state by Ulsoor PS. This is in Bangalore. Ulsoor PS. In criminal appeal number 1597, 98, 99 and 1600 by 2022. Dated 30/9/2022. Held that, please remember, under Section 25 of the Indian Evidence Act, voluntary statements of accused, even though they are videographed statements, they are inadmissible. So please remember, statements given by the accused to the police is not covered under Section 161 CRPC, and definitely it is not admissible in evidence. Important points they have discussed. Right. Now this matter relates to crime number 600 by 2000 under Section 302 IPC of Ulsoor PS, which occurred on 11/10/2000 in Ulsoor PS area, wherein, please remember, the deceased S. Ramakrishna, aged about 70 years, and who was living alone, whereas his daughter and son-in-law were residing elsewhere in Bangalore itself. He was done to death by unknown persons. The neck was cut, and definitely it's a case of murder for gain. They have taken away his properties. So as already told you, he was living alone in the house. And actually around 1:30 or 2 a.m. the neighbor has seen the doors kept open. He got a doubt. Luckily he did not go inside the house immediately. He informed the son-in-law, "Arey Baba, your father-in-law, is he here or not?" "Yes, he is here." "But the doors are kept open. What happened? Please come and see. I think he is an old man, senior citizen," like that they have told. But this son-in-law came there and found the dead body of his father-in-law, that is Ramakrishnan, in the kitchen. Actually, he found some burning sensation also. Anyway, dead body was found in the kitchen, and the properties have been lost. Yes, so definitely cash is missing. All these things. This is a heinous crime. We all know case of murder for gain. And the accused, Dodda Hanuma and 4 others, a dacoity gang, they were arrested in another case actually, 674 by 99 under Section 354 and 397. Another dacoity case of Vijayanagara PS on 31/1/2001. That means after 3 or 4 months, the gang has been arrested in Vijayanagara PS, and there they confessed that they have committed an offence in Ulsoor. Immediately they brought him, or they reconstructed the scene of offense and found the accused, and definitely the offense has been tallied. So please remember, the entire scenario has been videographed by a police constable by name Sadashiva. So actually the arrest was shown on 8/2/2001, and please remember, they made a confession before the police in the presence of the mediators. Please remember, and they stated that they committed some theft of jewelry, and they promised to give a, that is a recovery as also promised. Yes, the recovery also was done. Right here, please remember, the case was charged under 302 read with 34 of the Indian Penal Code before the 4th Additional Session Judge Mayo Hall. They were written like this. I don't know that place. Bangalore City. So here the important point. Now you have to consider this. So the A1, A3 and A2. Right. They were convicted basing on the videograph of the entire transaction. Entire thing videographed and played before the court. Sessions judge and High Court also believed the same and convicted them. That too, what conviction they have given? Death sentence. No doubt it is a heinous offense, we have to agree. But giving death sentence basing on the videographic evidence is not at all correct. Supreme Court had said the court has to weigh balance between the liberty of an accused and the possible, please remember, prejudice that may get visited on the societal interest. So please remember, even though technology we have to improve, technology we have to accept, at the same time should be according to the law. So when it is videographed means the presence of police is established. So 25. If any confession is made in the presence of police, it is vitiated. It is not really, you cannot prove it. So gone. Even though the Sessions Court and High Court believed the videograph evidence, Supreme Court said no. So ultimately, the orders of the High Court are set aside. Very good judgment. Please read it and improve your legal knowledge. Thank you.